Members, we'll get the Public Safety and Security Policy and Finance Committee underway. We have a few things to do today, plus we have session at noon. So we'll start with the roll call.
Johnson.
Here.
Lomer. Hillstrom.
Here.
Beckerfin. Considine. Dean. Frankie.
Here.
Grossel.
Here.
Howe. Lucero.
Here.
Newberger. O'Neill.
Here.
Pinto.
Here.
Uglum. Ward. Zerwas.
Okay. Representative Lucero, have you had a chance to review the minutes?
I have, Mr. Chair, and I move the minutes.
All those in favor say aye. Aye. Opposed? Thank you. They will start off with House File 3436, Representative Knoblach. I will move to lay over House File 3436 for possible inclusion in the omnibus bill. Representative, do you have a DE2 amendment?
Mr. Chair, I have the DE2 amendment, and I'd appreciate you moving it so I can get the bill in the shape that it needs to be.
Okay, the chair will move the DE2 amendment. All those get it in the shape the author wishes. All those in favor say aye.
Aye.
Opposed? Representative Knoblach, you may continue.
Well, Mr. Chair, members of the committee, I'm here with my co-author, Representative Hillstrom, on House File 3436. As amended, House File 3436 returns our policies on having audio and video in the courtroom to what they have been for decades. That is a requirement that, absent agreement from the defendant, the victim, the prosecutor, witnesses under subpoena, and the judge, there cannot be publicly available video and audio in criminal cases. This policy has served us well for decades and should be continued. To hold criminals accountable, law enforcement officers and prosecutors must have the cooperation of victims, witnesses, sometimes children, and certainly jurors. Media coverage by its nature hinders this cooperation, making it less likely that testimony that is needed is given. If reporting a crime means the world can watch a report on the 10 o'clock news or see it forever on YouTube or elsewhere, some victims and witnesses will decide it's just not worth it. Media coverage adds nothing to the truth-finding process of the courts. The courts are public. They are open. The media covers the courts daily. Defendants, witnesses, and victims can and frequently do talk to the media outside of the courtroom. But by its nature, the most media-worthy cases will also be those that are the most heartrending for victims and families. Will a young woman who has been sex trafficked want to testify about what happened and what she did, knowing her testimony will live forever on the internet, always available to a future spouse or boyfriend? Should a mother have to hear the details of her child's murder over and over again on the 10 o'clock news? What public purpose does this serve? Even less salacious cases will sometimes involve people who are shyer by nature and less willing to have their words and faces publicly exposed. The primary purpose of the court is to find the truth and render judgment. Media presence in the court does nothing to help the courts fulfill this primary purpose, but has every possibility of hindering it. Please support our justice system by supporting House File 3436 as amended, and I yield to Representative Hillstrom for any comments she'd like to make.
Representative Hillstrom.
Thank you, Mr. Chair and members. Members, I'm a co-author on this bill because I too have concerns about cameras in the courtroom and when it's appropriate and when it's not. But ultimately, under Minnesota law, the legislature, we pass rules and laws, unless it's substantive, a substantive right to a defendant or victims, the court rule would trump state statute. And so I believe that it should be a substantive right for the defendant to waive or not, and a substantive right for the victim to waive or not. That's why I'm a co-author on this bill, and I would stand for any questions as well.
And we have, Mr. Chair, a couple of witnesses. If you want to go to that now, or we can take questions at your pleasure.
Why don't we move forward with witnesses?
Okay.
Caroline Palmer. Welcome to the committee. Please state your name for the record and proceed.
Thank you, Mr. Chair. My name is Caroline Palmer, and I'm the Public and Legal Affairs Manager at the Minnesota Coalition Against Sexual Assault. And I'm here today to speak in support of this bill and to thank Representative Knoblach, Representative Hillstrom, and yourself, Mr. Chair, for advancing this conversation. MnCASA has followed the issue of cameras in the courtrooms for over a decade. And while we recognize there may be some limitations when it comes to criminal sexual conduct cases, our bigger concern is the public understanding of what is actually public in the courtroom. People see courtroom coverage on the TV all the time. They don't know what the rules are. Victims of sexual assault, whether adults or children who have not reported the crime, will likely not know the procedural rules that go into media coverage of a trial. And if they see if a judicial process is potentially open, or even if there's a perception of openness, victims may be less likely than ever to report the crime. They see footage from courtrooms around the country and have no reason to believe it's not the same here. I want to say that research supports this reality. Going back to 1992, the most comprehensive study of rape in this country, called Rape in America, a report to the nation, found that only 16% of victims ever report. And researchers identified one of their main fears in this report as media coverage. And these findings are really supported by more recent research as well. The U.S. Bureau of Justice Statistics showed in 2010 that anywhere from 15.8 to 35% of all sexual assault cases are reported. These are still very low numbers. And other noted researchers, such as Dean Kilpatrick, who's one of the leading authors of studies on victim response to the criminal justice system, has found that the fear of the system remains a high factor for victims. Some may argue that the Me Too movement has changed this and has made reporting easier. And yeah, for some people, I think it has. But I would caution that there are many, many more victims for whom circumstances have not changed at all, and they still cannot come forward easily. Economic burdens, for example, mean that a victim cannot risk coming forward to bring their case, and they simply cannot bear the loss of income that might come with that. We've often heard and still continue to hear that victims are just seeking fame, that they're seeking publicity, that they're seeking money, that they're not believed. The stigmas and stereotypes are very pervasive. And I will say that many survivors who have spoken out have been vilified in social media, with some even receiving rape threats. So the message I think that comes back to victim survivors is that it's still not safe to come forward, and having cameras in the courtroom, I think, only is going to further the belief that there may be some risk to them. I really want to emphasize that MnCASA believes that an open and transparent justice system is really important. We believe that an independent media monitoring governing activities is very important too. But we also know that sexual assault victims still do not perceive the criminal justice system as a safe place for them, no matter how hard we try to ease that experience. And I'm not talking about the criminal courts alone. Civil courts can also be an area where people are very reluctant to come for sexual harassment cases, for sexual abuse cases, and even a protective order in a domestic abuse or sexual assault situation. At the end of the day, we just cannot risk creating any further barriers for victims seeking justice. Not only are they deterred from reporting, but we as a state are losing the opportunity to hold the offenders accountable who have created the harm. If we lived in a society where victim credibility wasn't continually challenged, I wouldn't be up here today and I would be celebrating. But the fact is, it's challenged every single day. And as long as we have that skepticism and disbelief for victims in our society, at this point we have to remain concerned about cameras in the courtroom and other media that can really influence the way victims see the system and their chances in that system. So thank you, and I'll stand for any questions.
Does not appear to be any questions at this time. Charles Hembrett. Beck.
Hello, I'm Charles Hempeck with Anna Marie's Alliance, and thank you for hearing me this morning, and thank you to Representative Hillstrom and Knoblach on putting forth this bill. Anna Marie's Alliance is a local nonprofit organization in St. Cloud working to end domestic violence through intervention, advocacy, and education. Anna Marie's Alliance is nearing its 40th anniversary as an organization, which gives us a unique perspective on the needs of the victim survivors. Our legal advocates help people understand and navigate both the criminal and civil justice systems. We meet with victim survivors immediately after a domestic violence incident, while law enforcement is still present. This helps ensure that they know what services are available to them. We follow the criminal proceedings and in partnership with the county attorney's office, keep them informed of what is happening throughout the process. We also assist in filing orders for protection and accompany them to a hearing if requested. Last year, we attended nearly 1,700 criminal and civil hearings. Anne Marie's Alliance is also part of the Stearns County Domestic Violence Partnership, which is an extension of the Stearns County Felony Level Domestic Violence Court. This system-wide response focuses on holding offenders accountable while ensuring victims are supported throughout the criminal proceedings. Anne Marie's Alliance knows that victims are not always willing to participate in criminal cases for legitimate reasons. They are worried about their safety and that of their children due to previous threats by the offender or the offender's family. It may be challenging to take time away from work, especially if they are now the primary breadwinner for the family. They may feel ashamed or responsible for what happened, especially if this isn't the first time their partner has been arrested for domestic violence. For the majority of the women and men we work with, confidentiality is of the utmost importance. There is still a stigma attached with being a victim of domestic violence. With all the aforementioned reasons why a victim might not want to participate in a criminal hearing, I don't think we should add one more possible barrier like allowing cameras in the courtroom. Victim survivors are often dealing with many layers of trauma, and we work hard with all of the systems people involved to ensure victim survivors are not re-traumatized during the court process. I don't see a benefit to potentially broadcast the trauma that people may have to relive during a court hearing. People generally understand that defendants have rights, but victims have rights as well, and they should continue to have the right to say whether cameras are allowed in the courtrooms. Thank you. I can take any questions if you have any.
Not appear to be any questions at this time, so we'll move on to Mark Anfinson.
Good morning, Mr. Chair, members of the committee. I'm Mark Anfinson. I act as general counsel to the Minnesota Newspaper Association, the trade association of all the state's newspapers. I speak in opposition to the bill. The motives of these proponents of this bill are perfectly understandable and, in fact, commendable. We have no problem with that. What we do have a problem with is the methods the proponents are proposing to achieve their goals. What you've heard so far from both the authors and the witnesses who've testified are claims almost completely divorced from current reality in Minnesota, okay? Almost completely divorced of facts. I would like to share with you a few actual facts that will give you some context for this proposal. For the last 10 years or so, the Supreme Court of Minnesota has been involved in a very slow, tortuous, laborious process to allow cameras in courtrooms to some limited extent. I've been in the middle of that because I've acted as attorney for a group of media petitioners that have sought the court's help in liberalizing camera access rules. The court has conducted 2 pilot projects over that period of time to study the impact of cameras. One, a few years ago, it did in civil cases, and for the last 2 years, the court has been conducting a pilot project for criminal case proceedings. Okay? In the course of those pilot projects, the purpose of the court has been to acquire empirical information, in other words, facts, to assess not based on propagandistic claims about the impact of cameras in courts, but actually what happens when cameras are allowed. And the results of the pilot projects have shown that cameras cause absolutely no discernible problems for anybody in Minnesota courts. None. There is another impact, though, that has been established as well, and that is that members of the Minnesota public, your constituents, residents of this state, have for the first time in the state's history been able to see what actually occurs in courtrooms, which, if you know about that, is normally pretty impressive, but until a few years ago is completely barred to the public. And in particular, in criminal cases, the cases that typically concern the public the most, for good reason, members of the public have been able to see people who commit terrible crimes that have caused great concern among the public generally, brought before the bar of justice and sentenced for what they did. Now, all this talk about victim concern and exposure of the justice system to this terrible pestilence of cameras has, again, no basis in reality. I'm going to tell you a few points briefly. And, Mr. Chair, I respect the committee's time, but this is an important issue. Let me tell you two more things to conclude my testimony. One, what the current Supreme Court rule governing cameras in courtrooms actually says, what it allows and doesn't allow, which is as follows. This is the current Supreme Court rule that allows cameras in criminal proceedings, the focus of this bill, okay? The only portion of a criminal case that can be captured on camera, audio or video, is the portion of the proceeding that occurs after a guilty plea has been obtained. Nothing, none of the testimony of victims, none of the testimony of witnesses, none of the proceedings in the court during the trial are public. I'm sorry, can be captured on video or audio. Only when the defendant is going to be sentenced can cameras come into the courtroom. And that's it. Okay? No audio or video coverage is permitted at all when the jury is present in the courtroom. None. No coverage of any kind is allowed in a proceeding held in what they call problem-solving courts, which are the specialized courts that deal with drugs, mental health, veterans, and DWI. No coverage at all under the current court rule. No coverage whatsoever is permitted in cases involving charges of criminal sexual conduct or in cases involving family or domestic violence. No coverage. And no audio or video coverage of any kind is permitted of a testifying victim unless the victim affirmatively acknowledges in writing before testifying to the coverage. That's the current court rule. So what you end up with in current criminal proceedings in Minnesota under the Supreme Court's pilot project rule is that defendants who have committed terrible crimes and who are being sentenced by the court get to be shown on television or on a website of a newspaper. And the question I have for the committee and the proponents of this bill is, why is that a bad thing? What is wrong with allowing people to see a court sentence of a person who's committed a terrible crime? It's baffling to me. We're not talking here about any victims being shown, any witnesses who don't want to be shown, any portion of the trial, only that little final segment of a criminal case. Okay, now one final point. As I said at the outset, I think it's important here as we look at an issue like this that we focus on facts, not on propaganda, okay? Not on speculative claims that are not connected to reality. Minnesota has tiptoed along the path of cameras in courts now for almost 10 years. No problems have been identified. But it's still a tentative experiment. What isn't tentative is the fact that approximately 40 other states in America have routinely allowed camera coverage in all civil and criminal proceedings for 30 years. Okay? Wisconsin, North Dakota, Iowa have allowed almost unrestricted camera coverage of civil and criminal cases from beginning to end for 30 years. When the Supreme Court was considering this issue several years ago and establishing the pilot, we had a prosecutor come over from Wisconsin, a criminal prosecutor, and he testified in favor of Minnesota liberalizing its camera rules. And he was challenged very vigorously by the Supreme Court's advisory committee. And at one point in his testimony, he leaned back and he said, "Folks, quit looking for the boogeyman. There is no boogeyman with cameras." This was a criminal prosecutor from St. Croix County. So, I appreciate the motivation of the proponents. Their concerns are legitimate. But if you look at the facts, if you look at reality, and you look at the experience in Minnesota over the past 10 years, as well as many other states, this bill is unnecessary. It will only hurt Minnesotans who desire to see a little bit more about what their courts do. Thank you, Mr. Chair.
Thank you. Any questions? Representative Hillstrom.
Thank you, Mr. Chair. Sorry, I had to move over here because now I'm on the committee and I get to ask questions. But Mr. Anfinson, this has been a slow creep of the court, and you've been talking about how this pilot project started off as civil and then has moved to criminal. So it's clear that that's the direction that the court is going to. And so while you may be specifically talking about the court rule as it is at this minute, that doesn't mean that there isn't a need for the state legislature to decide on a matter of public policy whether or not we should weigh in on whether or not we think victims or defendants should have a substantive right. You have made it clear that for 30 years other states have been doing this, so it's clear the direction you would like to see the state go. So, Mr. Anfinson, do you believe it's improper for this legislature to decide if a victim or defendant should have a substantive right in the courtroom with relationship to cameras in the courtroom, or do you believe that's solely within the discretion of the court?
Mr. Chair, Representative Hillstrom, I know what you want me to say, Representative Hillstrom, but I'm not going to say it. The legislature has absolutely no right to get involved in this issue. How's that? No, that's not my position at all. Of course the legislature should have concern about this issue. My response to that question is that there's no imaginable, empirically justifiable reason for the legislature to enter this topic now. The Supreme Court has already done it. You talked about the Supreme Court's slow creep on this issue. I think that exaggerates the speed with which they're proceeding. I have been very frustrated with the court, to be candid with you. I think they should move faster and further with allowing members of the public to see what happens in criminal courtrooms. But they haven't. And the singular, overwhelming, emphatic concern of the court for 10 years has been protecting victims and witnesses. Why would anyone think they're going to suddenly change? Especially when they have a majority of Democrats on the court now. That's a shot, Representative Hillstrom.
Representative Hillstrom.
Thank you, Mr. Chair. So, Mr. Anfinson, if this were reversed, if the legislature was weighing in and saying absolutely every courtroom should be open to every court, every jury should be able to be videoed, every victim should be able to be videoed, every defendant, would you be supporting that proposal if we were flipping it? Would you be saying we, the legislature, should be driving to allow you to be in the courtroom more?
Mr. Anfinson?
Mr. Chair, Representative Hillstrom, I certainly would be. And the reason I would support it is because it would be doing a great service to your constituents so they can see what good work the courts do. People don't understand how impressive the district courts of this state normally are. And they can't see that unless they can see it on television or on websites. And so the reason I would support that flip, as you call it, Representative Hillstrom, is because, again, as I've said, in 40 states for 30 years, there has been no documented evidence of any problem for anyone, including victims and witnesses. But I respect especially the victim testimony, and I don't personally have the slightest problem with placing restrictions on placing them on camera. But that's not going to happen. It's not going to happen with the court. It hasn't happened in 10 years. It's not going to happen in the next 10 years. And the other concern here, Representative Hillstrom, is we're not just talking about limiting camera coverage of a victim. This amendment that has been placed on the bill this morning demolishes any real prospect of camera coverage of criminal proceedings. That's a disservice to the residents of the state.
Representative Hillstrom.
Thank you, Mr. Chair, and this will just be my final comment. So your testimony was that the legislature shouldn't weigh into this policy. But what your testimony should have been is the legislature shouldn't weigh in unless you want to expand the cameras into the courtroom, because that is what you just said. And so I believe that is the role of the legislature to make a determination on whether or not we believe that victims and defendants have substantive rights with regard to this issue. Whether you agree with how far it should go or how far it shouldn't, it is the role of the legislature to decide what rights people have. And I'm just going to stop there.
Representative Beckerpin.
Thank you, Mr. Chair. So first, I just want to say that this isn't a joke. What happens in a criminal proceeding is a very serious thing for the parties directly involved. And I understand that it can be entertaining or interesting to people, but ultimately, I think that our justice system should be focused on achieving justice. And I think that your testimony particularly is a prime example of how people act differently when they're performing for the public or believe that the public is watching. And so I think that, you keep saying that nobody has a problem with it, and that you respect the testimony of the prior testifiers, but those things, that doesn't even make sense. If you truly respect the testimony of the prior testifiers, then you would give their testimony credence. And you don't speak for the advocacy community, and they've spoken well for themselves, and I think that we should all listen to what they're saying about the effects. And so if nobody has a problem with it, which is what you're saying, that nobody has any problem with the cameras in the courtroom, then why not allow the people directly involved to decide whether they want the cameras in the courtroom? Because apparently nobody has a problem with it. So if nobody has a problem with it, then we may as well let the people directly affected share their opinion about whether they have a problem or not. So I think, it's disingenuous to state that nobody has a problem with it, and it's disingenuous to undermine the testimony that we just heard from the advocacy community.
Mr. Chair.
Mr. Anfinson?
Representative, you mischaracterized my testimony. You do so in a fairly fundamental way. I never said nobody cares. What I said was there are no facts that have been acquired in 30 years of extensive camera coverage in this country showing any of the impacts, in fact, have happened that the proponents of the bill describe. I care deeply about the victims. I have spent hours and hours and hours over the last several years in promoting camera coverage through the Supreme Court and talking to victims advocates who have convinced me this is a big issue, and I respect it deeply. And it's not my testimony as you've described it. This is a big concern. But when you talk about why shouldn't the people affected be allowed to decide, who is affected when there's a serial rapist at loose in the community? Who is affected when there are murderers killing children in the community? Is that just the victim? Is that just the witness? Or is it the community itself who's affected? And when you see a person who commits a terrible crime like that brought before a court, brought before a district court judge, and sentenced to life in prison, that provides an enormous community benefit. Those are the people affected. It's a huge catharsis. It's reassurance that our justice system works. It's a demonstration that we live in a society that gets people like that and puts them away. That's the benefit of the camera.
Representative Frankie. Representative Beckerpin.
Thank you, Mr. Chair. And to clarify, you previously stated that nobody has a problem with it. I never said that you said you didn't care.
I didn't say no one has a problem with it.
Representative
Thank you, Mr. Chair. In the committee, we talked through the chair. I know.
I understand the protocol.
Mr.
I also
Anfinson, let's-
understand that we're supposed to properly
Mr.
summarize the
Anfinson.
testimony of a witness.
Mr. Anfinson, you will speak through the chair. You will speak when you're asked to.
I appreciate that.
Representative Beckerpin has the floor at this time. She will start talking. When she is done, I will let you have a chance to respond.
Mr. Chair, I apologize to you and the committee.
Thank you,
Representative Beckerpin.
Thank you, Mr. Chair. To be clear, court hearings are, for the most part, public already. Many of the people here in this room and here at these tables have been present at court hearings. We certainly know who the criminals in our community are. When I'm not in this building, I spend my days in the Hennepin County Government Center, and it's We've all seen the pictures of the people leaving the courtroom. We've all seen the video of them walking across the government center, walking across that federal area in front of the federal courthouse. We all know who those people are. The lack of cameras in the courtroom hasn't stopped us from knowing who the criminals in our community are. We all have seen mugshots. The idea that we're somehow shielding a rapist or a murderer by not allowing a camera in a court proceeding is ridiculous. So again, we need to be focusing on justice and achieving justice for the people who are directly affected by court proceedings. And if there clearly nobody has a problem with it, then I don't see how it's a problem to let the people directly affected, members of the public, the defendant, the victim, the prosecutor, who represents the state and all of us, make that decision.
Mr. Chair? may I
Mr.
respond?
Anderson?
Again, Representative, with respect, I think you misdescribed my testimony. I'm not saying the lack of a camera in a criminal courtroom shields anybody. What it does is provides a reassurance, a catharsis, a demonstration of how the justice system works. And that has enormous value to the people whose court system it is, after all. This isn't about grandstanding for the cameras or increasing ratings. None of that happens. All I can do, I'm not going to take the committee's time to correct what you've said I testified to as opposed to what I did. Everyone's heard what I said. I go back to the central premise, which is nowhere in the United States is there a documented study showing that camera coverage of criminal court proceedings does anything that harms victims or witnesses or the system of justice itself. There's plenty of evidence, however, that people appreciate the ability to see what their courts do. And I will also say it's a benefit to the courts to have this public access. There's a reason the Supreme Court is proceeding down this path. Because number one, it's been gradually persuaded that there are no serious negative impacts. And number two, and equally as important, the court, I think, is being persuaded that it benefits the courts to have greater public visibility and engagement, which can only come through a camera. After all, the cliche is still true here. A picture is worth 1,000 words. And in certain types of complex legal proceedings like criminal cases, that's clearly true.
Okay, members, we do have a number of bills to go, so I do ask that you, with your comments, keep them short, because we do have session at noon. Representative Frankie.
Thank you, Mr. Chair. I just wanted to make a brief statement to something Mr. Ampson had said. You don't really need to respond to this, Mr. Ampson, but the shot at the Democrat courts and Democrats insinuating that this is a partisan bill, and people understand that this is brought forward by the chair of Ways and Means, who is Republican, and co-authored by Representative Hillstrom, who is DFL. I just think that needed to be reiterated and pointed out that even though sometimes I would like to take shots at the DFL myself, this was not the appropriate time to do so in context with this bill. So to remind people that this has bipartisan support. Thank you.
Mr. Chairman, could I respond to that? I'll be brief. Mr. Chair, Representative, it is always a treacherous gambit to use humor either in a courtroom or a legislative hearing. And I have testified here for 30 years. I understand that better than most people. I nonetheless occasionally try and inject a little humor. Not because I have any disrespect for the authors of this bill, not because I have any respect for the court. I didn't seriously mean that a Democratic Supreme Court would be different on this than anyone else. And Representative Knoblach is well known as a Republican to me. This is a bipartisan bill. And it's nice to see that over here. But in no sense that I mean disrespect or suggest this is some kind of a partisan effort. It's not. I know that.
Representative Constantine.
Thank you, Mr. Chair. And please don't respond. If somebody wants to see how well our district courts work, they can simply drive down and sit in the back. This is reality TV, and that's all it is. Thank you.
Okay, next on the list is Sonia Miller.
Mr. Chair, can I just say something to this?
Representative Knoblach.
Well, first, Mr. Chair, members, Mr. Anfinson, I was listening very close to his testimony, said, quote, "No problems have been identified," unquote. But members, there actually is a Minnesota Supreme Court Advisory Committee on Rules of Criminal Procedure that issued a report in December 2017, and a minority of the members, 6 of them, were against extending the pilot project on cameras in the courtroom. And let me just briefly quote from the report. It said, "Members who oppose permanent codification note that coverage under the rule is unfair to defendants because they do not have the same right to deny coverage as victims do. The presence of cameras distorts the process and that people may behave differently due to the presence of cameras, and brief coverage of sentencing hearings sheds no real light on what happens in the course of a criminal case, provides no real public educational value, and creates more work for those involved. Finally, members opposed are concerned that permanent codification of the cameras in the courtroom pilot rule may lead to a slippery slope expansion of coverage." So Mr. Anfin says, well, no problems have been identified. Here are 6 people on the Supreme Court Advisory Committee of Rules of Civil Procedure who have, in fact, identified problems. And finally, Mr. Chair, in the St. Cloud Times on March 28, 2016, Mr. Anfinson was quoted, "The domestic violence exception to the current rule has proven to be, quote, far more applicable in the view of judges than I expected it, and I think more applicable and problematic than the Supreme Court anticipated," Anfinson said. That exception is, quote, "depriving the public from a lot of information about some of society's worst crimes," he said. So clearly, Mr. Anfinson's desire is, even though the rules as they are quite constricted, it is his desire and that of his organization he represents to greatly expand this to domestic violence and other cases.
Mr. Chair, can I respond to that last comment? Because
Mr. Hanson, I'll give you about 30 seconds.
That's
We
all
have
I'm
a-
gonna
We
say.
have a lot to do yet, and we have session in an hour and 5 minutes.
Mr. Chair, I respect that. Again, it's an important issue. In terms of that quote in the St. Cloud Times, and of course, we have to assume the St. Cloud Times correctly quoted me, but I think they did. My point, which I would make again today, is that certain terrible domestic crimes are being completely excluded from camera coverage because of the breadth of the rule. I'll give you the quick example. A couple of years ago, a man murdered his wife and cut her body up and put her in a freezer. And he was eventually found and convicted of murder. And his sentencing, again, all we're talking about under the current rule is the sentencing. The sentencing of this man was prohibited under the current rule because it was a crime of domestic violence. That was the only point I was making. In no sense do I believe that the court coverage of cameras in domestic cases normally should be expanded.
Representative Pinto.
Thank you, Mr. Chair, and I'm sorry. I thought that you'd seen me before, so my apologies. I just want to build on Chair Knoblach's point that that it's striking to me that even this really small rule that Mr. Anfinson is talking about, even that is opposed by a number of people looking at it, giving the reasons that the Chair Knoblach provided. On the other side, if members look at the report, the support for expanding the rule is, well, in general, we haven't seen too many problems. And I found it really striking in Mr. Anfinson's testimony that I believe he said there are no serious negative impacts, and on the other hand, it benefits the courts. And I find that striking that it does feel to me that we can be focusing a lot on this individual narrow rule, but it is clear in the testimony that the hope is that the path, we do continue down this path, that we do have a flip, so that we do have this, we are expanding this. And when you look at the reasons for it, there doesn't seem to be much of a benefit for public education for this narrow piece. And of course, the argument's going to be made that we need to have more and more of it. And then on the other hand, the negative consequences come more and more. And finally, I'd just like to point out, has been made before, courtrooms are open. I've had many trials as a prosecutor. I cannot think of a single trial where it was closed, where members of the public, anybody who wanted to, except for, I suppose, people, there's people who were witnesses in the case, could not sit in that courtroom and know what's going on. Courtrooms are open, and they have been open for many, many years and will continue to be. Thank you, Mr. Chair.
Thank you very much, Mr. Chair, members of the committee.
Sonia Miller. Please introduce yourself. Welcome to the committee.
Thank you. Good morning, Mr. Chair and members of the committee. My name is Sonia Miller Van Ort, and I'm here today in my capacity as president of the Minnesota State Bar Association and its 15,000 members. I'm here today, as I understand the legislation that's been proposed and even the amended version that's been posted, to speak in opposition to the bill. What I want to clarify first is on the substantive issue that you've been hearing testimony on regarding the use of cameras in the courtroom. On that particular issue, I can inform you that the MSBA took a vote yesterday, and its position to the Supreme Court will be opposing the continuation on the permanency of the camera in the courtroom for criminal proceedings, which has been a pilot project that you've heard about. So on that substantive issue, the MSBA is in alignment with the legislation that you're looking at. Reasonable minds can differ, certainly. You've heard different viewpoints. But on the substantive issue, our association is in agreement. So the question is, why am I sitting here then today? Why am I opposing the bill? The reason that the MSBA has asked to be present today is to voice a separate concern concerning the bill. And that is that as written and even as proposed in amendment, it calls into question a significant impact to the separation of powers on which our country and our state is fundamentally principled. As you all know, and I think about this when I go to schools and I speak to school children, as probably many of you have done, and we talk about separation of powers. And we explain to children that there are 3 branches and that each one of those institutions has its own responsibilities of governing and operating 3 distinct areas: the executive branch, the legislative branch, and the judiciary. And when we explain that to children, we explain that that's because we want a balance of power, and we want those different branches governing those things that fall under those different branches. And we know, and we tell our children that this is a great way for government to exist because it inspires trust in the public to know that there's a checks and balances. And that even when we've got different people in leadership that people agree with or don't agree with, they can still have comfort in a system that we have of checks and balances and separation of powers. So the concern that the MSBA has with the legislation, again, is not the substantive issue, but what the legislation seems to be suggesting is that it would be appropriate for the legislature to dictate to the separate branch of the judiciary how it should conduct its business and how it should govern the administration of justice, which is its primary function. It's in that way that we have a concern. The judiciary has a process. They are responsible for courtroom rules, decorum, how justice is going to be carried out in that courtroom. And it's a difficult job, but that's what they're taxed with. And this legislation seems to take some of that power away from the courts and to say instead the legislature should decide how the judiciary branch should carry out that business. So simply on that basis, it's a philosophical basis, it's a fundamental basis of our government and the legal principles supporting it, that the MSBA respectfully requests that you reconsider the legislation that's before you and how it's been styled and formed, and to think about how that impacts the separation of powers concept and what message that sends in undermining the judiciary and in some ways even undermining the fine legislature and all the wonderful things it does in its area of expertise and potentially undermining the public's confidence in our system. Thank you. I'm open to any questions if there are any.
Representative Hillstrom.
Thank you, Mr. Chair. We had a conversation before the committee hearing started, and I understand that you're in alignment with the lack of cameras in the courtroom. So do you believe that we could address that issue by simply making it a substantive right for the victim and the defendant? Would that take care of your separation of power issue?
Potentially. I guess without seeing exactly how it's been drafted, I can't respond completely. The issue, I think, the check, what we're suggesting we need to keep in mind is, does what the legislature create impede on the judgment of the court and how it's carrying out the administration of justice? So there may be a way that the legislation can be written where that doesn't happen, but that's our concern. And that would be our concern regardless of substantively what was in the bill.
Thank you. We have one more witness, Mr. Hal Davis. While he's coming up, I'll remind members that we have 4 bills to go, and we are in the process of reserving a room for tonight at 8 o'clock if we cannot get through them.
Mr. Chairman, members, my name is Hal Davis. I'm a member of the Legislative Issues Committee of the Minnesota Coalition on Government Information. It's my first time testifying before any legislative committee, and I'll try to observe the protocols. We oppose HF 3436 as amended. Minkoji supports expanding cameras in Minnesota courts as a way for the public to see what happens in its courtrooms. Cameras let the public observe government officials perform important duties that only a select few can witness in person. Such coverage provides the public with information vital to its role in a functioning democracy and helps ensure that the information disseminated is more complete and accurate. You might say it's the best evidence. As Minnesota Supreme Court Associate Justice David Lillehog recently said, the more transparent and accessible the courts are, the greater the trust in the judicial system will be. As the Minnesota Supreme Court will soon face a major decision on cameras in its district courtrooms. For the past 2 years, the pilot project has allowed news organizations to capture video and photographs inside some sentencing proceedings, and they'll soon decide whether to make that policy permanent. Minnesota stands out among its neighboring states. Citizens in Wisconsin, Iowa, and North Dakota are accustomed to seeing televised and photographed court action. In many other states, cameras are a routine sight at the trial court level. Several states, including Minnesota, have studied the impact of electronic media coverage on courtroom proceedings. Nationally, it's been reported that the extensive empirical evidence that has been collected on the impact of electronic coverage has established that such coverage is not detrimental to the parties, jurors, counsel, or courtroom decorum. The Minnesota Supreme Court Advisory Committee on Rules of Criminal Procedure assessed the 2-year pilot program. They reported no disproportionate minority representation, which was a major issue. Disruption to criminal proceedings was overall is minimal. Audio and visual coverage provides greater public exposure to criminal proceedings, which increases the appearance of transparency. And the overall impact on the proceedings was neutral to positive. In some cases, crime victims welcomed camera coverage. A man in Le County, whose wife plotted to kill him, agreed to be photographed and videotaped as he read his victim impact statement. He wanted people to know what he and his daughter endured. Minkoji believes it's time to let the people see what goes on in the people's courtrooms.
Thank you. Members, we are going to be laying this bill over so we can have more discussion on it later if we need to. Representative Knoblach, do you want any final comments?
Well, I just want to thank you, Mr. Chair, and members of the committee. Thank you, Representative Hillstrom, for co-authoring the bill with me. I know this has taken a lot of time, but this is a very, very important bill, and so I appreciate your attention, and as it goes forward, I would appreciate your support. Thank you.
Thank you. With that, I renew my motion to lay the bill over for a possible inclusion as amended. All those in favor say aye. Aye. Opposed? Thank you, Representative Knoblach.
Thank you, Mr. Chair.
Next, we have House File 3707, Representative Erickson. And I'll move to re-refer House File 3707 to Education Finance.
Thank you, Mr. Chair and members. I'm here as the Chair of Education Innovation Policy and the author of the Omnibus Bill, in which I need to include a cross-reference to 609.352 in regard to the definition of sexual abuse under the Maltreatment of Minors Act so that the Department of Education can investigate these kinds of cases. And I have with me Caitlin Snyder from the department who will explain to you why this is necessary for the commissioner to have this authority. Thank you very much.
Ms. Snyder?
Thank you. Members of the committee, Mr. Chair, my name is Caitlin Snyder, and I'm with the Minnesota Department of Education. Chair Erickson covered the bill pretty well. So the new language is on page 5 of House File 3707 under the definition of sexual abuse, and it would add a cross-reference to 609.352, solicitation of children to engage in sexual conduct and communication of sexually explicit materials to children. We've had a number of instances reported to the department for maltreatment investigations that currently we've been able to investigate under existing authority regarding threatened sexual abuse on line 6.6. But we would like to add this cross-reference to 609.352 to make sure that there's no ambiguity about our ability to investigate these situations, particularly as there's increased electronic communication between students and teachers. This authority already exists for the Department of Human Services and the counties, and I would stand for any questions.
Members, any questions? Any public testimony? Okay, with that, I will renew my motion to re-refer House File 3707 to Education Finance. All those in favor say aye. Aye. Opposed? Thank you. Motion.
Thank you, Mr. Chair and members.
Next, we have House File 3924, Representative New. Okay. Representative New, you are up. As she's coming down, I will make the motion to House File 3924 to re-refer to Environment and Natural Resources. Representative New, welcome to the committee, and you may begin.
Thank you, Mr. Chair and members. This is my first time presenting in the committee, and there are treats, so.
Okay. Good job.
So I assume that will help. Just by way of brief introduction, you may have heard that in January of this year, a little boy, a little 8-year-old boy, Alan Geisenketter, was killed by a man who was drunk driving a snowmobile in Chisago County. The man who was on that snowmobile had been convicted of multiple DWIs. His driver's license had been revoked multiple times, and he had ignition interlock on his car. That was sort of the impetus for this legislation coming forward. What I found is that in existing statute, if you get a DWI on an ATV or a snowmobile, you lose your driving privileges on those off-road vehicles for 1 year. In addition, your driver's license can also be revoked under DWI law for driver's licenses. There is currently a first-time exemption for that, if for your first DWI on a snowmobile or off-road vehicle, and this bill would get rid of that first-time exemption. In addition, the reverse is not true. If you get a DWI in your car or truck on the road, you of course have the DWI penalties for that, but it does not affect your driving privileges for a snowmobile or ATV. So this legislation changes that. It links those two things back together and gets rid of that first-time exemption. In a nutshell, that's what we're doing here, and I do have a couple of testifiers to the bill.
Okay. First testifier will be Colonel Smith. Oh, my mistake.
Okay.
Can't remember your name.
Christian Franzen. Mr. Chair, members of the committee, my name is Christian Franzen, and I'm testifying on behalf of the Minnesota United Snowmobile Association. MinUSA is a statewide association of snowmobilers' families. In that, we are here to support this bill. Since the tragedy of Chisago County, We have sought out law enforcement and others to talk about solutions that may help prevent such a tragedy in the future. We feel that this bill is a step in the right direction, and we look forward to working with you as the bill moves through the process. We'd also like to thank the bill author for her leadership in the effort. We ask that you support the bill, and thank you very much.
Thank you. Any questions from the committee? Colonel Smith.
For the record, Rodman Smith, Director of Enforcement, Department of Natural Resources. Mr. Chair, members, I'll be brief. The department would like to thank Representative New for bringing this forward. There has been a loophole for drunk driving when it comes to recreational vehicles and motorboats for several years. This would help close that loophole and make people that not only drive vehicles but also drive recreational vehicles much safer. So I can stand for any questions.
Thank you. Any questions amongst members? Is there any other testifiers?
I believe there's one more.
Welcome to the committee. If you could please state your name for the record, and you may proceed.
Mr. Chairman, members of the committee, my name is Ray Bone. I'm here representing the All-Terrain Vehicle Association of Minnesota. And I just want to say that we strongly support this legislation. We were actually a little dumbfounded when we heard that we were actually being treated a little differently than the other vehicles, cars, because our premise all along is that we were treated the same. And frankly, we have no problems with that whatsoever. We should be treated the same as other vehicles. And we appreciate Representative New bringing this forward, and we do support this legislation wholeheartedly.
Thank you. Any public testimony? If there's no other questions, I re-refer my motion for House File 3924 to be re-referred to Environment and Natural Resources. All those in favor say aye. Aye. Opposed? Motion approved. Thank you, Representative New. And
New who? Must have been the donuts.
Yeah.
next, we have House File 3356, Representative Zerwas.
Thank you, Mr. Chair. Members, I think the motion is to go to the general register.
Yes, it is. If you want to make that motion.
I'll make that motion, Mr. Chair. And Mr. Chair, members, there should be an amendment in the packet. It's the D3 amendment. I'd like to move the DE3.
Okay, the author has moved the DE3 amendment. All those in favor say aye. Aye. Opposed? Go ahead.
Thank you, Mr. Chair. Members, House File 3356 ends driver's license suspensions for unpaid traffic tickets. There's a broad consensus around the need to limit driver's license suspensions to violations that involve dangerous driving, but not to further criminalize someone's inability to pay. The origination of this bill is as politically diverse as both the National Center for State Courts and the Southern Poverty Law Center and the American Legislative Exchange Commission. So it has broad bipartisan support. Alec's resolution on this issue is in your folder, and it limits driver's license suspensions to violations involving dangerous driving conduct. What the bill does, the amended bill in your possession stops driver's license suspensions when the only violation is failure to pay a traffic ticket. It eliminates the additional suspension period after paying a ticket for driving after suspension, because that technically right now, when you send in your fine for that, you're pleading guilty, and it would lead to another 30-day suspension. And it maintains the collection process already set forth in law so that people are still held accountable for their tickets. It's handed over to a debt service collector. The Department of Revenue can garnish someone's wages or withhold it on their income tax, their state income tax refund. Nothing in this bill changes how current law handles suspensions for DUIs, reckless driving, or habitual offenders. And so I think that's really important. There's no ability or thought that by taking away the revocation or the suspension on an unpaid ticket, that someone will be able to just drive like wild and rack up tickets and have no consequences. The habitual offender portion of the statute will still remain in place, and you would be suspended for the multiple infractions over the period of time. I have several testifiers in respect for the committee's time. I think I'll hand it over to my testifiers and then be available for additional comments, Mr. Chair.
Thank you. You want to introduce your first testifier?
Yeah, my first testifier, Mr. Chair, is a young woman that dealt with the multiple driving suspensions in the past.
If you could please state your name for the record and continue.
Thank you, Mr. Chair, members of the committee. My name is Leah Jackson. I grew up in Otsego, Minnesota, and I now live in Minneapolis. Now I work as a restaurant server and a dance instructor for St. Paul Parks and Recreation. Thank you for the chance for me to tell you about how these driving suspensions have caused a significant impact on me both financially and occupationally. In October of 2014, I was taking a left turn at a green light yield. I pulled out into the intersection like I was taught in driving school. I was waiting for a break in traffic, giving me proper time to make the turn. As the light was turning yellow, the last car sped up, causing me to have to wait longer and was not able to complete the turn till the light was red. I was pulled over immediately and told that pulling out into the intersection was illegal. I was given a ticket for obstructing traffic and intersection gridlock, which cost $135. I was 20 years old at the time. I had just gotten a new job as a store manager of a retail store and had just moved into a new house. I was out of town at my initial job training when I was driving back to the hotel when I got the ticket. I hadn't gotten my first paycheck yet, as these were just the first few days on the job, and I had to make sure I could save up enough for rent and food. So I didn't have the money to pay for the ticket right away. I actually wasn't sure how long I had to pay the ticket and thought I would get to it after I had gotten a few paychecks and knew I could cover the basics. I ended up moving again a couple months later into my own apartment, which delayed me being able to pay for this ticket even longer. The following February, I was pulled over and told my license was suspended, and I was given a driving after suspension ticket that cost me $200, plus all the fees and surcharges, even though I was never notified of the suspension. Though I had just moved, my mailing address and the address on my driver's license was still my parents' house, so I should have received my notice there, but nothing ever came. So I had no idea I was suspended until I got pulled over and got the ticket. By now I had about $500 in fines, and I knew I wouldn't be able to pay it until I received my tax refund. Part of my responsibility at work was to make deliveries and bank runs for the retail store that I worked at, so I kept driving so I could keep my job because my boss wasn't happy about the situation. Within about 2 weeks, I received 2 more driving after suspension tickets, one while I was making a bank run and one while driving from one job to the other. After that, I started asking friends and employees to come pick me up during my shift and to drive me to the bank and to my dance classes so I wouldn't get any more tickets. On days when they couldn't, I really wasn't able to fulfill my duties as a store manager. I was so stressed because not only was I in trouble at work, but I also had to miss family dinners and events, and I still couldn't save money to pay off the debt. When my tax refund finally came, I went downtown to the government center and was able to speak with a hearing officer who reduced my fine from about $900 to $625. I paid it off and was able to get my license back, but my problems weren't over. Because of driving after suspension tickets, my auto insurance eventually dropped me as a client, and I wasn't able to find new insurance for less than $1,000 a month if they would accept me at all. Luckily, I was connected to a broker through a restaurant customer, and he was able to find me insurance for $650 a month. It's been 3.5 years, and I still pay $535 a month for insurance, which is way higher than ever before the tickets. If you add up the total cost of these tickets, plus the increase in auto insurance I've been paying for the last 3.5 years, the total is about $13,400. If my license hadn't been suspended, I would have been able to continue driving for work. I would have been able to keep my car insurance at the much lower rate. I would have been able to save money from my tax returns and work over the years. I know it's important for people to drive safely, but it doesn't seem right for one traffic ticket to add up to over $13,000 in costs for me. I hope the legislature will figure out a way to stop suspending the driver's license for people who might not be able to pay the whole cost of the ticket right away. Because with that $13,000, I wouldn't have had to live paycheck to paycheck. I wouldn't have been pushed further into debt, and I wouldn't have been kept from pursuing further education, and I would have been able to live a more comfortable life. Thank you, Mr. Chair.
Any questions from the members? Representative Hilstrom.
Thank you, Mr. Chair, and I guess the question is for you, Mr. Chair. I was just having a conversation with fiscal staff here with the retroactive license reinstatement section under Section 5. I don't know that there's a fiscal cost. There might not be one, but I'm in supportive of the proposal. I'm happy to have it go to the general register, but Mr. Chair, if there is a cost to this, are you prepared to pay for this in your bill later?
Oh, if something comes up, then we'd probably have to call it back.
Okay.
Any other testifiers?
I think I do have 2 more testifiers, Mr. Johnson, or Mr. Chair.
We'll start with Susan Segal.
Good morning. Thank you, Mr. Chair, members of the committee, and I've already thanked Representative Zerwas. I am Susan Siegel. I'm the city attorney for the city of Minneapolis. And I can tell you it's not every day that the city of Minneapolis is here supporting legislation also supported by ALEC. And it's also not every day that me as a prosecutor are here working hand in hand with the Hennepin County Public Defender's Office. But such is the nature of criminal justice reform that smart reforms is something that we can all get our arms around and make progress on. As the city attorney, important part of my job is to promote a safe and livable city, but it's also to work smarter. We prosecute approximately 17,000 cases a year, handle them in our office. And we are not soft on matters that involve public safety. Just back in 2015, we were here pursuing a bill, and this legislature enacted it to create a new gross misdemeanor crime for reckless driving. We have used that new offense, and just this last year, we obtained 3 gross misdemeanor convictions for really tragic deaths of pedestrians, that if the drivers had simply been watching where they were driving instead of what else they were doing, these people would be here today. So we are aggressive when public safety is at issue. But on this issue of suspending driver's licenses simply for unpaid fines and fees, it does not serve the purpose of public safety. If anything, it may harm it because you probably have more people driving because they have to get to work or to take care of their kids, and then driving without insurance, which drives up all of our insurance rates and is not a good result for any of us. So I think I'm happy to answer questions. I think this bill makes a lot of sense. There are deterrents still because if there are moving violations, after you get a certain number, you will still lose your driver's license. So that's the public safety angle of this, but simply just for failure to pay fines and fees, it is not pursuing the goal of public safety. And we regularly see people who have thousands of dollars worth of fines. It's difficult to go to court and to get these fines excused by a judge. It requires several trips down in Hennepin County, if you're in Minneapolis, down to the Hennepin County courthouse or one of the 2 suburban courthouses. It requires a lot of time and a lot of ingenuity, which people who may be holding down minimum wage jobs and multiple minimum wage jobs at that, plus trying to manage a family, it's a lot of stuff to balance. So it doesn't mean that they're scofflaws necessarily, but just get caught in this unending cycle of adding without really, a positive impact for the system.
Representative Considine.
Thank you, Mr. Chair. And to the first testifier, $13,000 is just ridiculous, and I'm sorry you went through that. Representative Zerwas, this is a great bill, and thank you for bringing it forward. Is there really anybody in here that's against it? Can we just move forward? Yeah, I'm good to go. If do we need to keep going, or
That would be up to Representative Zerwas.
Representative Zerwas?
Mr. Chair, members, we can stand for questions.
Any questions from the members? Representative Pinto.
Thank you, Mr. Chair. And really, I just want to.
Thanks a lot, Dave.
I was going to say thanks, but yeah, maybe I should come up with a question now. No, I was going to say, when you have the Southern Poverty Law Center and ALEC, when I looked at this, I was like, oh my goodness, wow, you've got both those groups in support. So this is good stuff. So I just want to thank Representative Zerwas and then the city attorney and all the folks from Legal Aid. And this is a great coalition coming together. So many thanks to you.
Anybody from the audience wish to testify? Okay, with that, do you wish to renew your motion?
Mr. Chair, members, I wish to renew my motion to re-refer House File 3356 as amended to the General Register.
With that, all those in favor say aye. Aye. Opposed? Congratulations, you're on your way. One bill left, members.
Even a blind hog gets an acorn now and then.
House File 3172 of the Representative Zerwas. Keep that reservation free,
Thank you, Mr. Chair. Members, I'll make a motion that House File 3172 be referred to the General Register.
Okay, with that, Representative Zerwas.
Mr. Chair, members, House File 3172 was brought to me by the Minnesota Home Care Association. Under current law, if a registered predatory offender is admitted to a nursing home or assisted living facility, the facility must be notified of the offender's registered status. This bill would apply the same requirement when a registered predatory offender is admitted for home care service, to alert staff that would be sent to the individual's home to let them know that the person they're going to take care of is on the offender registry. At this time, I have Kevin Goodnow, the representative for the Minnesota Home Care Association, who could provide some other background information and be available for questions.
Mr. Godot.
Mr. Chairman, members of the committee, Kevin Goodnow, representing the Minnesota Home Care Association. I don't really have a lot to add. I think Representative Zerwas' testimony covered what the bill does and why we're doing that. We have run into situations where some of our members have found out after the fact, after providing services in a person's home, that the person actually was a registered predator. And in order to protect the employees that we're sending out into the homes, we want to make sure that we have that information so we can prepare the care plan accordingly. And so the Minnesota Home Care Association strongly supports the bill and would appreciate your support.
Thank you. Is there any questions? Representative Ward?
Thank you, Mr. Chair. Just a quick question. What kind of precautions do you take then?
Mr. Godot?
Mr. Chairman, Representative Ward, the type of precautions, so there's a care plan developed, and so within that care plan, they would have to make a determination based on the risk associated with sending somebody in, what precautions they would have to make. And I don't know what those are, quite frankly. It would depend on what what the challenges are with the individual and what the potential risk is to the individual being served. It may be as simple as saying certain people won't be sent out into the home, or they won't be sent out alone. But it will depend on what the profile of the individual is.
Any other questions amongst the members? Is there anyone in the audience that wishes to testify on this bill? With that, the Representative Zerwas, you wish to renew your motion.
Thank you, Mr. Chair. Members, I'd like to re-refer House File 3172 be referred to the General Register.
All those in favor, say aye.
Aye.
Opposed? Your motion moves forward. Thank you, Mr.
Thank you,
Representative
Mr. Chair.
Zerwas.
Thank you, members.
And with that, we will be adjourned.